Hello and welcome. This is David Lentz. Please be advised that this video really only discusses Virginia state court cases. If you have a federal case, please contact us and tell us about your case. Thanks.
Hello folks, this is David Lentz, attorney at law. Thanks for watching this video and thanks for visiting our website davidlentzlaw.com. If you've been served with a criminal warrant or with a traffic summons, I'm sorry, and I know that's extremely stressful, but we're here to help you to get the best result in your case possible given the facts and circumstances of it. Let me sort of run through briefly a little bit of the landscape here. All conversations that you and I would have would be in the strictest of confidence. I don't tell the police officers, I don't tell the judge. It's confidential. You need to know that. And I take that oath very, very seriously. Let me just say this. We always seek full acquittal, and you have a right to testify or not to testify in a case. We would discuss that further in our consultation. But we go thoroughly through the facts and circumstances of your case to see if there's what the best approach is to obtain full acquittal, meaning you have no penalties, no conviction, no record after the case. We make sure that the police have proper evidence, and what I mean by proper admissible evidence is that they didn't obtain evidence in violation of your Fifth Amendment rights to be free or not to convict yourself with incriminating statements and to be free from unreasonable searches and seizures under your Fourth Amendment rights. If we find that the police did not give you things like your Miranda warnings, which are your right to remain silent, they should have told you that anything you say can and will be used against you, and that you have a right to an attorney, and that if you cannot afford one, that one would be appointed for you. If they didn't tell you that at the appropriate time, then any statements you made to the police officer may not be admissible. Unfortunately, we find that a lot of people, I would say more than 50% of criminal defendants or people charged with traffic offenses, what they really did, and they didn't realize at the time, was they convicted themselves while they were trying to talk themselves out of the charge. So that Fifth Amendment issue is extremely important in most cases, and we thoroughly investigate whether or not we can keep any statements you made to the police out of evidence. Another thing is the right to be free from unreasonable searches and seizures. We make sure that if the police conducted a search and got some drugs, and found drugs or drug paraphernalia or weapons or whatever, that they got a warrant. And if they didn't get a warrant, we either object to that, or if there was some exception to the warrant requirements, we make sure that situation existed or didn't exist to see if we should file a motion to suppress on that ground. Let's talk about your right to a jury. You have a right to a jury in any case where you can potentially be given jail time. Now that's true in all Class 1 misdemeanors. Every Class 1 misdemeanor carries potential jail time, and in all felony cases. And I believe also in Class 2 misdemeanor cases, I believe also potentially carry jail time. But there are so few Class 2 misdemeanors, but that's beside the point. So anyway, ask about your right to a jury. Okay, let's talk about fees for a second. Now, the amount of fees that we charge is very much going to be dependent on what the actual facts and circumstances are of your case. And so it's very difficult to generalize, but to give you some general idea, everything depends on the number of witnesses that are involved, how many charges you've been charged with, whether that's felony or a misdemeanor, what your prior record is,
And another biggie is whether or not we're going to have to file motions to suppress evidence that the prosecution may want to introduce into evidence because that evidence violates your Fourth or Fifth Amendment rights. And a really big issue is whether a jury is going to be requested or not. Okay, but a general idea. In the simplest misdemeanor case, they're usually about $500. The complex ones average about $1,500. Felony cases where there's no jury involved, normally they go from about, on average for us, the fees end up being about $1,200 for the simpler ones and about $2,500 for the more complicated felony cases where no jury is requested. Now, when a jury is requested, not only do we have to assume that all those hearings are going to have, those 4 hearings are going to have to be attended, but also I've never had a jury trial that's lasted less than a day because we have jury instructions to argue about. They have to be prepared, and then we have jury selection, and then the jury has to deliberate afterwards. So I've never had a jury trial last less than a day, less than 1 full day. So the bottom line is I don't take jury trials for less than $5,000. And on average, our experience has been the jury trials run between $7,000 and about $12,000. But again, it's very case specific. If you got a really complicated case that could last maybe several days or something, they could go beyond that. So I hope that gives you some idea about the attorney's fees.
Okay, let me just say this. No lawyer, myself included, or any other lawyer, can guarantee you results in a case. The reason for that is we don't know what the police officer is going to say. We don't know what the other witnesses are going to say. Sometimes witnesses will tell you one thing, and then you get up on the stand, and they say something else.
Okay, I need to interject here that while we do seek acquittal in all cases, sometimes it appears, even before going to court sometimes actually, that the evidence is going to be heavily against the client, and that we might be better served to engage in plea bargain discussions with the prosecution to try to get a more lenient sentence. Naturally, we try to get the best deal possible. That may mean, work release instead of jail. It may mean home incarceration instead of jail. It may be some sort of diversionary program, and naturally in DUI cases, where possible, which is pretty often actually, we can get restricted driver's licenses in DUI cases along with the ASAP program. This goes part and parcel with the notion that the best we can ever do is give you a guesstimate, an educated guess as to what we think the outcome is going to be in a case, because litigation is inherently uncertain, and results can never be guaranteed.
I have over 35 years of experience. I used to be, many years ago, on the court-appointed list in Chesterfield, City of Richmond, and in Colonial Heights. Don't do court-appointed work anymore, but who knows? And you don't really know what anybody's going to say on the witness stand until they get up there and testify. Now, like I said, I repeat, you have a right not to testify, and your prior record is going to have a big effect on whether or not we're going to want you to get up on the witness stand. But you always have a right to testify if you want to testify. But you must do so truthfully if you get up and testify. What we want to do is we want to work hard on your behalf to get you the best possible result in your case. Let me just say this. When you come to the initial consultation, it's always best to bring all your court papers, every piece of paper that the police or a court officer or anybody has given you, your warrant, your summons. Also, go to the state police website if you've been charged with a criminal offense and get a copy of your criminal record. That is really the only way I can give you a fair assessment of whether or not what you're likely, what I think a guesstimate, an educated guess of what your outcome is going to be. is to know what your prior record is. So if you can bring that to your initial consultation, that would be just excellent. If you just have a traffic case or a DUI, please go to DMV and get a copy of your DMV record. Okay, let's work together hard. You can call us to set up an appointment. The best way and the most convenient way, though, is to go onto my website, go to the Ask Leave message page, shoot me an email telling me when you want to set up an appointment. If you request a time some afternoon or on the weekends between 10 and 2, I almost always can accommodate you.
Normally, I can accommodate any request for a phone appointment within those times I just mentioned if you give me at least 3 hours prior advance notice.
If I can't do it in the time you've asked for, I'll let you know right away and we'll reschedule. But in the mornings are bad because I'm usually in court, and that's the time when I'm almost never available to the phone.
Okay. This is my website, davidlentzlaw.com. You can visit there to learn a little bit more about me. There's a description, a resume on here somewhere about us. Recommend that you read the page, free legal advice. This video can be found on this page right here. You can even pay your fees here. There's spots for that. And if you want to email us, we very, very much encourage our clients to have email accounts. You can ask or leave a message on here. On this site. So those are the pages. You just click on them, and down here as well. But in any event, I want to thank you for visiting us. We'll work hard for you, so let's see if we can't work together and get the best possible result given the facts and circumstances of your case. And I will talk to you next time. This is David Lentz. Thanks a lot for visiting.